I often get asked whether or not family violence cases or family violence charges have to go to trial. Well, have to, no. Should, sometimes yes. Ultimately, with every criminal case, we're talking about whether or not a case is going to end in some kind of plea agreement or if it's going to go to trial. And there's going to be consequences. There's going to be consequences of accepting some type of plea agreement versus a risk on whether or not we're going to trial. Because if we go to trial, we're going to always be in front of a jury. Almost always going to be in front of a jury. There are some circumstances where it would be in front of a judge only. But when we're talking about a trial, we're talking about a risk assessment. And what the probable outcome of that trial is, and what the probable punishment would be if that trial is ended unfavorably, versus what that negotiation has been. If that negotiation is unfavorable and the possibility of going to trial through our risk assessment is better, then obviously the best legal advice is to take that to trial. But it's going to be fact specific to the person. And that's why you need someone who is able to understand all of that, be able to go through that risk assessment with you and make sure that you can understand those pros and cons and those risks. We do that in all of our family violence cases at DGL. We want to make sure that you're able to make an intelligent, informed decision on whether or not this case needs to go to trial or whether or not we need to accept a plea agreement. And whatever path you take, we are very experienced in that. We pride ourselves in being trial attorneys. We can do that for you and make sure that your rights are protected and you are defended. So if you've been watching this and you have any questions about criminal defense, please call our office. We offer free consultations and we'll be happy to answer any of your questions.